Good afternoon, everybody. My name is Eloisa Ayala, and I am the supervising immigration attorney for our immigration unit here at Legal Aid Service of Collier County. Today, we'll be talking about recent changes in asylum law. These changes just occurred this year, they are all still ongoing. That means that recently there have been other rules published, which are not yet in effect, but we expect them to be published later on this year. However, perhaps with changes for next year, we might see these rules be taken back or changed or delayed. At this point, we're not sure. For now, I'm only going to talk about what is already into effect. So mainly I will be focusing on two different rules. The first rule was published on June 22nd, 2020, and it became in effect August 21, 2020. This rule removed a 30-day regulatory provision that gave USCIS 30 days to either grant or deny an application for employment authorization for asylum applicants, meaning when an asylum applicant filed their application for employment authorization, whether it was the first time or a renewal of it, USCIS had 30 days to make a decision. This in turn created a ripple effect of employment cards being given out pretty quickly. We were seeing a month from the time of application to the time of approval and even having the card in their own hand. This was made so that applicants wouldn't have to wait too long to be able to obtain employment. Obviously, this created more work for USCIS and more expenses, and having to hire more staff to comply with this rule, which is why which is the reason why we think it was also removed to help them save costs to comply for this 30-day regulatory provision. So now this 30-day rule is gone, meaning USCIS can take pretty much whatever they want in deciding whether to grant or deny the employment authorization application. What this means is that most of the applicants and our clients will likely be waiting an undue delay in their application and receiving their work card, and therefore creating unemployment for a number of applicants. This is already a vulnerable community, which now is now even more affected by having to wait an uncertain amount of time in receiving their work card. The second rule makes changes to the eligibility criteria for applications for employment authorization for asylum applicants. These changes were published on June 26, 2020, and came into effect on August 25th, 2020. There are some lawsuits pending that created some class actions, and members of those class actions are exempt from those rules. If you're wondering if you could be part of those class actions, I would suggest you contact an attorney. But for now, I will be talking about that rule in general applies to everyone since it is in effect right now. So the following slides pertain to this second change in rules. And again, these became in effect August 25th, 2020. So one of the rule's most significant changes is the fact that more than a twofold increase in the time period asylum seekers must wait before they can apply for an initial employment card decision. The rule also codifies certain unresolved delays in the asylum adjudication process that results in the denial of an EAD application, meaning EAD, Employment Authorization Documentation, work card, if attributed to the applicant. So let's look at the chart below. Again, these provisions that you see in the chart only apply to applications filed on or after August 25th, 2020. It only also applies to those initial employment card applications, meaning if the person already has a card and is only renewing that card, this does not apply. This only applies to those applying for that work card for the first time. So first of all, here in the middle column, we have what the regulation was prior to August 25th, 2020. And in the column to the right demonstrates the difference on or after August 25th, 2020. So the rule affects when asylum seekers can apply for an initial employment card. So before, individuals would apply once they've had 150 days after the filing of their asylum, and USCIS would be able to grant that employment card authorization 180 days after the asylum application. With the new rule in effect August 25th, 2020, now they must wait 365 days after filing for an asylum. So before it was 150 days, now it's 365 days, a whole year after. Also, again, this second bullet on the right, no limit on USCIS processing time of initial EAD application. Back to what I was mentioning, that before they had the 30 days and now there is no limit. Oops. Regarding the delays in the asylum process and how that affects employment card eligibility. So before we had what we called the asylum clock. USCIS had this asylum clock where the days would start counting up to your 150 days when you could apply for that work card. Prior to the rules, delays caused by applicants would toll the clock. Meaning, for example, if you did not show up for your fingerprint appointment, that would toll the clock until it was solved. Those days would not count towards the 150 days. That was before the rule. With the new rule, there is no asylum clock anymore. There is simply just 360 days after the filing of asylum. But now, with any delays caused by the applicants, USCIS will reject any initial employment card applications for delays caused by the applicant at the time of filing. So before there was a toll on the clock, which you could solve and just go back on it, have the days back counting again. Now they will just simply reject the application in itself. Until it was remedied. So the rule says that USCIS will deny any initial employment card application if there is any delay requested or caused by the applicant in the adjudication of the asylum application that is still outstanding or has not been remedied by the time applicant files the EAD application. This will likely cause an increased amount of denied applications, and this is very worrisome, as many of these applications now cost over $410. So therefore, it is very crucial for an advocate, an attorney, to examine if there is any problems that may arise. It is our job to make sure that the applicant does not lose their money because of this. And therefore, it's even more imperative for the applicant to be very sincere to their advocate, the person helping them fill out this application, so that the attorney can know if there are any applicant cost delays that will cause a rejection by USCIS. Okay. This is a flow chart published by a nonprofit organization, which has been very useful to us in determining whether an applicant is eligible for a work card application after the August 25th, 2020 new rules. So what we're doing is we pretty much go through these flow chart every time we file an employment card application for anyone that is an asylum applicant. We want to make sure we do not, again, cause the client to lose their money because of one of these issues. So again, you see here whether the application, authorization application was submitted prior to the rule, meaning if it was postmarked August 24, 2020 or earlier, and again, that in that case, the old rules would apply. So none of these issues would be in effect. However, if the application authorization, if the employment authorization application was filed postmarked on or after August 25th or later, then you have to go through number 1 to 5 to make sure that there is no issue that will cause an application to be denied. And again, number 1, you see the time bar, the 365-day waiting period, which I've discussed. And I will go into detail regarding number 2 and number 3 and number 4. Again, on number 5, you see the delay bar, and that's what I've just spoken about regarding whether the applicant caused a delay at the time of their asylum application, meaning, like I said, as an example, whether they had to reschedule the fingerprint appointment, or whether they asked the judge for a continuance hearing, or if the applicant schedule of their asylum interview, for example. There is a list published by the rule of what examples of those applicant cost delays would be. So again, as you see with the flow chart, I will move on to now number 2, which is the EWI bar. So that means EWI means entry without inspection. So this is the bar based on attempted entry without exception. Again, this is a new bar. 2020 new rules. This rule bars initial and renewal employment card eligibility for individuals who entered or attempted to enter the United States other than port of entry on or after August 25th, 2020. So there are exceptions, and these are it. Those who entered without inspection will be barred from filing a work card application and will be barred from receiving that work card unless they presented themselves to a DHS agent without delay, but not later than 48 hours after their attempted entry. Or they indicate to a DHS agent their intent to apply for asylum or express a fear of persecution or torture, and or otherwise have a good cause for the attempted entry as determined on a case-by-case basis. Meaning if they tried or attempted to enter without inspection, meaning they did not show up at a port of entry, they would have to fall under one of these exceptions to apply for a work card. If they entered at a port of entry, then that would not be an issue. Okay, now back to the flow chart. On number 3, the 1-year bar. So the bar based on the 1-year filing deadline for asylum, under the new regulations, individuals who missed their 1-year filing deadline for asylum and filed their asylum application on or after August 25th, 2020 are barred from both initial and renewal employment card eligibility. Again, there are exceptions and limitations. So, under asylum law, their applicants are required to file their asylum application upon the 1 year of having entered the United States. This bar means that if that individual does not file their asylum application within that 1 year, then they are barred from a work card. The exceptions are for those who are unaccompanied children at the time of filing their asylum, or and if when an asylum officer or immigration judge determines that they meet an exception to the 1 year filing deadline. The date controlling this rule is the filing date of the asylum application, not the filing of the initial or renewal employment card application. For example, Adela entered the United States on January 15, 2020, and filed her asylum application on August 1, 2020. Let's assume she entered January 15, 2019, and she filed her asylum application August 1, 2020, more than the 1 year. So even though she filed her asylum application after the 1 year deadline, she would still be eligible for a work card because the new rule would have not been in effect yet. Meaning if she applies for a work card before this August 25th, 2020, then that wouldn't be an issue. After the August 25th, 2020, and this new rule being to effect, she could not apply at all for a work card. Sorry, that was a little confusing. Okay, we spoke about the bar based on entry without inspection. And finally, the rule also expanded on bars related to crimes. So currently, individuals convicted of an aggravated felony in the United States or abroad at any time are barred now for employment card eligibility. And this is regardless of the dates they filed their asylum application, or regardless of the time that they filed their employment card application. So for example, if Lisa already has an employment card authorization for several years now, and then now she commits a felony and she seeks to now renew her work card, she will not be eligible. Also, individuals convicted of a particularly serious crime on or after August 25th, 2020 are now barred for employment card authorization. Individuals for whom there are serious reasons to believe they committed a serious non-political crime outside the US are also now barred from work card authorization. So let's go back to this flow chart. Again, here it makes a difference whether their work card application was filed on or after August 25th, 2020. If it was, and if it will be, then you have to go through these 1, 2, 3, 4, 5 bars, which are now new to the rules, and determine whether they are eligible or not. We spoke about the time bar having to wait 1 year, 365 days after the filing of their asylum application. We spoke about the EWI bar, meaning the entry without inspection. Did they enter entry without inspection? Do they fall under an exception? And number 3, 1 year bar. Did they file their asylum application more than 1 year after their entry to the United States? And whether they fall under an exception. And number 4, are they barred because of an aggravated felony or a particular serious crime or a serious non-political crime outside or inside the US? And the delay bar, has the applicant caused any delays? And if that could bar them too. So as you can see, because of these new rules, applying for a work card is not just now, hey, just fill out a form and you're good. Now you actually have to go through these and make a determination of whether that person can even submit their application. And again, this is very important because you want to make sure that your client does, or that you are eligible for a work card and not lose your money. Again, I encourage everybody who wishes to apply for asylum and who wishes to apply for a work authorization card based on your asylum to reach out to us for help regarding these new rules. And I will love to another day also go into what is asylum and what are the requirements for an asylum. Thank you again for joining us, and until next time.